If you decide to draft a will and exclude some of your dependents from your retirement fund, the trustees are empowered to override this decision. The trustees usually look at who are the people that were financially dependent on you before you passed away. And even if you do not nominate some of your dependents as beneficiaries, the trustees can include them as beneficiaries.
Upon your death, the trustees conduct an investigation into your beneficiary nominations to ascertain who were financially dependent on you during your lifetime. And, they don't want to leave them without financial support. So the trustees then decide how the money should be paid out, and even over and above the deceased member's wishes.
Beneficiary nomination form is a very important document for the trustees, but you're right in saying that it is not the be-all and end-all. It is not 100% binding on the trustees in that they have to follow it. By law, in terms of the Pension Funds Act, they have the discretion to override it.
Employees are required to nominate beneficiaries of their retirement fund and to update the information when their circumstances change. If you fail to do this, your former spouse could benefit from your pension fund when you pass away. Your illegitimate children also have the right to benefit from your retirement fund, especially if they were dependent on you financially. The trustees can sometimes take up to a year to decide how the money should be distributed, and this can put a financial burden on your dependents.
These investigations can last, quite some time, and your descendants or your family normally in certain circumstances requires financial support immediately. So this investigation can take up to 12 months before they actually decide, who they can pay out to.
If one of the beneficiaries feels that they've been treated unfairly, they can challenge the trustee's decision. A complaint can be lodged with a pension fund adjudicator who will investigate the matter on your behalf.
It's important, to your earlier point, that most members take the time out to understand their benefits, understand the discretion that needs to be applied, understand that you need to also inform your family members about your benefits, so they also understand when there's a claim to be put in, etc. So I think knowledge about benefits is a very important theme coming out of this discussion.
The Pension Fund Act prohibits creditors from claiming against your pension fund, and you need to establish from your employer whether you have approved or unapproved death benefits.
When it comes to the changes on the Insurance Act, that's referring more to your unapproved group death benefits. What is an unapproved group death benefit? It's an employer-owned insurance policy that provides death benefits to the employees. Those are governed under the Insurance Act. That's a different piece of legislation, and there it's very clear-cut in how it needs to be determined. There's no trustee involvement. There's no discretion. It's either you pay directly in terms of the beneficiary nomination, which was completed by the member. If there is no valid nomination in place, it must be paid into the estate.
Your pension fund benefits can only be paid into your estate if there were no beneficiaries and nominated dependents, but this will be done only as a last resort. Naledi Matlapeng, SABC News, Johannesburg.